Can you break your promise without being sued? Different is legitimate expectation from promissory estoppel. The answer to this question is what we will be dealing with today in this video. Promissory estoppel is a contract law doctrine applied in public law that allows an individual to recover damages from another even if there is no written contract. The doctrine applies when one person makes a promise that the other reasonably relies on and suffers a loss as a result. The doctrine prevents the promisor from going back on their word and ensures that parties do not take advantage of each other. Promissory estoppel is defined in Black's Law Dictionary as an estoppel which arises when there is a promise which promisor should reasonably expect to induce action or forbearance of a definite and substantial character on the part of the promisee, and which does include such action or forbearance and such promise is binding if injustice can be avoided only by enforcement of promise. The origin of the doctrine of promissory estoppel was first stated in Hughes versus Metropolitan Railway Company and Birmingham and District Land Company versus London and Northwestern Rail Company, old authorities from the House of Lords. The decisive case is that of Central London Property Trust Limited versus Hytrees House Limited in 1947, delivered by Lord Justice Denning.
In Evandon versus Guildford City Association Football Club Limited, Justice Denning stated, it applies whenever a representation is made, whether of fact or law, present or future, which is intended to be binding, intended to induce a person to act on it, and he does act on it. A promise may in the United States derive contractual enforceability if it has been made by the promisor, knowing or intending it would be acted upon, and the promisee has altered his position and reliance on it, notwithstanding that there is no consideration. The authorities are Allegheny College versus National Chateau Country Bank, Drennan versus State Paving Company, California. Under the English law, the judicial view is that the Crown is not immune from liability under the doctrine of promissory estoppel. This was stated in Robertson versus Minister of Pensions. Even in the United States, the trend in courts is strongly in favor of the application of the doctrine of promissory estoppel against the government and public bodies, especially in the Federal Crop Insurance versus Mariel case.
When we turn to the Indian law on the subject, it is heartening to find that in India, not only has the doctrine of promissory estoppel been adopted in fullness, but it has been recognized as affording a cause of action to the person to whom the promise is made.
Remarkably, as far back as 1880, long before the doctrine of promissory estoppel was formulated by Denning J. in England, a division bench of 2 English judges in the Calcutta High Court applied the doctrine of promissory estoppel and recognized a cause of action founded upon it in the Ganges Manufacturing Company versus Surajmal and another. The doctrine of promissory estoppel was also applied against the government in a case subsequently decided by the Bombay High Court in Municipal Corporation of Bombay versus Secretary of State. The doctrine of promissory estoppel was also held applicable against a public authority like a municipal council and Union of India and others versus Messrs. Indo-Afghan Agencies. That is in 68. Century Spinning and Manufacturing Company Limited and another versus Ulhasnagar Municipal Council and another. Turner Morrison and Company Limited versus Hungerford Investment Trust Limited. Radhakrishna versus State of Bihar in 1977, Motilal Padampat Sugar Mills Company versus State of UP in 79, and Union of India versus Godfrey Phillips India 1985, and Dr. Ashok Kumar Maheshwari versus State of UP and another in 1998. In Kasinka Trading and another versus Union India and another in 1995, it was held that the doctrine of promissory estoppel represents a principle evolved by equity to avoid injustice.
In Collector of Bombay versus Municipal Corporation of the City of Bombay, 1952, promissory estoppel was already recognized as a legitimate defense in equity and was held to found a cause of action against the government even when, and this needs to be emphasized, the representation sought to be enforced was legally invalid in the sense that it was made in a manner which was not in conformity with the procedure according to law.
This principle was built upon in Messrs. Union of India and Others versus Messrs. Indo-Afghan Agencies Limited, 1968. But the superstructure of the doctrine with its preconditions, strengths and limitations was outlined in the decision of Messrs. Motilal Padampat Sugar Mills Limited versus State of Uttar Pradesh and Others, 1979, by the Supreme Court.
Promissory estoppel, or the doctrine of estoppel, is a legal principle designed to stop a party from going back on a promise they have made to another party that has relied on it to their detriment. In both Indian and English law, for the principle to be enforced, the following hold true. For the principle to be enforced, there should be no ambiguity on the part of the party making the promise, which can be expressed or implied, and the person to whom the promise is made must have acted on the promise either to their detriment or have altered their course of action as a direct result of relying on the promise. The principle of estoppel relies on equity rather than law. In other words, it would be inequitable not to uphold a promise made to someone who had acted to their detriment because of the promise would be binding on the party making it, and he would not be entitled to go back upon it if it would be inequitable to allow him to do so, having regard to the dealings which have taken place between the parties, and this would be so irrespective whether there is any pre-existing relationship between the parties or not. Promissory estoppel is seen as an alternative to the doctrine of consideration. The doctrine of consideration means that a party who has relied on a promise has to give something in exchange, a consideration, for that promise. In other words, there must be some contractual arrangement between the parties. In UK law, it can be only used as a defense when a legal relationship exists. A defendant being sued by another party can claim promissory estoppel in their defense, but cannot use promissory estoppel to claim against a party that has gone back on a promise. In court, an objectivity test is used to determine the equitability of the promise. For instance, if the party to whom the promise was made does not rely on it to change their course of action, a court would not consider it to be inequitable if the party making the promise goes back. When we turn to the Indian law on this subject, India not only has a doctrine of promissory estoppel, but it has been recognized as affording a cause of action to the person to whom the promise has been made. The requirement of consideration has not been allowed to stand in the way of enforcement of such promise. It is not necessary for the promisee to show that he has acted to his detriment. All that he has to show is that he has acted to reliance on the promise and altered his position. Promise. The doctrine of promissory estoppel has also been applied against the government, and the law may therefore now be taken to be settled as a result that where the government makes a promise knowing or intending that it will be acted upon by the promisee, and in fact the promisee acting in reliance on it alters his position, the government would be held bound by the promise, and the promise would be enforceable against the government at the instance of the promisee, notwithstanding that there is no consideration to the promise and the promise is not recorded in the form of a formal contract. And this was stated in Mrs. Motilal Padampat Sugar Mills versus State of Uttar Pradesh and Others. The court in the State of Bihar and Others versus Kalyanpur Cement Limited. The doctrine of promissory estoppel can be invoked against the government to prevent fraud or manifest injustice. The burden would be upon the government to show that the public interest in the government acting otherwise than in accordance with the promise is so overwhelming that it would be inequitable to hold the government bound by the promise. The government would have to show precisely the changed policy with the reason and justification therefore, to enable the court to judge for itself which way the public interest lies and what equity of the case demands. This doctrine is also applicable against a public body like a municipal council. Bakul Cashew Company versus Sales Tax Officer. In this case, it was held that the representation must not only be definite, but it must be satisfactorily established. In this case, Motilal Padampat Sugar Mills was primarily engaged in the business of manufacture and sale of sugar,
An assurance was given by the state government that new Vanaspati units in the state, which go into commercial production, would be given partial concession in sales tax for a period of 3 years. The appellant mills, having set up such a Vanaspati unit, thereafter went into production of Vanaspati on July 1970, which was within the cut-off date set by the government, and sought exemption. The government apparently turned round and rescinded its earlier decision in August 1970, by which time the factory of the appellant had gone into commercial production. Having lost in the High Court, the appellant appealed to the Supreme Court. This was a decisive case discussing US and UK laws and laying down the principles for the operation of the doctrine in public law. State of Punjab versus Nestle India Limited, 2004. The finance minister of the state, while presenting the budget for the year 96-97, made an announcement that purchase tax on milk was to be abolished for the period from 1/4/96 to 4/6/97, and this was publicized in several newspapers in the state. On 4th June 98, the Council of Ministers decided the decision to abolish purchase tax on milk was not acceptable, and consequently authorities issued tax notice to the respondent requiring them to pay purchase tax on milk for the year 96 to 97. Supreme Court held the appellant had been unable to establish any overriding public interest. This is the state of Punjab, who was the appellant, which would make it inequitable to enforce the estoppel against the state government. In the next two decisions, the doctrine of promissory estoppel was accepted, but the remedy was varied in this way. Godfrey Phillips were manufacturers of cigarettes. This is in Union of India and Others versus Godfrey Phillips India Limited, 1986 AR 806. Godfrey Phillips were manufacturers of cigarettes. The Cigarette Manufacturers Association made a representation to Central Board of Excise and Customs that corrugated fiber board containers used for protecting cigarettes from damage are not an integral part of cigarettes, and their cost should not be included in the value of goods for the purpose of excise duty. The board agreed and issued a circular in those terms, but later changed back to the old policy by another circular. The Supreme Court held that the central government and the Central Board of Excise and Customs was clearly bound by promissory estoppel to exclude the cost of corrugated fiber board containers from the value of goods for the purpose of assessment of excise duty, but only during the period between the two circulars, as the promise operated during that period. Madras Cements versus State of Tamil Nadu. Pursuant to the issuance of GOMS number 29 Energy A2 dated 31/1/95, an infancy tariff concession was announced by the government with a cut-off date as 14/2/97 for establishing the industry. Madras Cement set up the industry before the relevant date with the view to get tariff concession, but due to delay in giving power connection could not operate it before 14/2/97, which resulted in refusal by the respondents in extending infancy benefit. The court allowed the plea of those who had informed about their readiness for getting power connection or made applications to the second respondent electricity board on or before 14/2/97, and also an opportunity to those who had established the industry prior to 14/2/97 to apply for and be considered for tariff concession. On 11th July 1986, the state government, by a government order, enabled those engaged in tourism promotional activities to become automatically eligible for concessions, incentives as applicable to the industrial sector from time to time, including exemption from building tax. Pursuant to this GO, the appellants began constructing the hotel building, which was completed in the year 91. Notice for filing returns under the Kerala Buildings Tax Act was issued to the appellants on 5th September 1988. The appellants replied that they relied upon the GO dated 11th July 86 and stated that they were under no obligation to furnish any return under the said act, as they were exempt from payment of building tax. On the High Court rejecting the case, the Supreme Court was approached by the hotel and said, "We find that the appellants, having relied on the said GO dated 11/7/1986, had in fact constructed a hotel building by 1991. It is clear, therefore, that the non issuance of a notification under Section 3A was an arbitrary act of the government which must be remedied by application of the doctrine of promissory estoppel, as been held by us here and above. The relief that must therefore be molded on the facts of the present case is that for the period when the relevant statutory provision was in force, no building tax is payable by the appellants. However, for the period post 1/3/1993, no statutory provision for the grant of exemption being available, it is clear that no relief can be given to the appellants, as the doctrine of promissory estoppel must yield when it is found that it would be contrary to statute to grant such relief.
When is promissory estoppel not applicable? It cannot be used to compel the government to carry out a representation of promise that is contrary to law or outside the authority of the state. State of Punjab versus Nestle India Limited, 2004.
When on the facts, equity would not require that the government should be held bound by the promise made by it, the doctrine of promissory estoppel would be displaced. State of Jharkhand and others versus Brahmaputra Metallics Limited. There can also be no promissory estoppel against the exercise of legislative power. State of Kerala versus Gwalior Rayon Silk Manufacturing Company. The plea of estoppel cannot be raised to defeat the provisions of a statute. Union of India versus R.C. D'Souza.
There can be no promissory estoppel against the exercise of legislative power. Held in State of Kerala versus Gwalior Rayon Silk Manufacturing Company Limited.
The doctrine of promissory estoppel is an equitable doctrine. It must yield where equity so requires. When on the facts equity would not require the government should be bound by the promise made by it, the doctrine of promissory estoppel would be displaced in such a case. These aspects were highlighted by the court in Vasant Kumar Radhakrishnan Vora versus Board of Trustees of the Port of Bombay, Sales Tax Officer and another versus Ms. Shri Durga Oil Mills and another, and Dr. Ashok Kumar Maheshwari versus State of UP and another, State of Jharkhand and others versus Brahmaputra Metallics, Ranchi and another. Promissory estoppel cannot be invoked to compel the government or even a private party to do an act prohibited by law. There can be no promissory estoppel against the exercise of legislative power. The legislature can never be precluded from exercising its legislative function by the doctrine of promissory estoppel. State of Kerala versus Gwalior Rayon Silk Manufacturing Company Limited. Excise Commissioner UP Allahabad versus Ram Kumar. The basic principle is that the plea of estoppel cannot be raised to defeat the provisions of a statute. In Union of India versus R.C. D'Souza, a retired army officer was recruited as assistant commander on temporary basis and was called upon to exercise his option for regularization contrary to the statutory rules. It was held it would not amount to estoppel against the department. Whether a promissory estoppel which is based on a promise contrary to law can be invoked has already been considered in Kasinka Trading and another versus Union of India and others in 95, as also in Shabi Construction Company versus City Industrial Development Corporation 95, wherein it was laid down that the rule of promissory estoppel, a declaration which is contrary to law or outside the authority or power of the government or the person making that promise, cannot be enforced.
It is different from promissory estoppel, but similar in that even though there is no explicit promise, some administrative action or policy implicit in it, a promise or right or expectation. In State of Jharkhand and others versus Brahmaputra Metallics Limited, Ranchi and another, 2020, the difference was discussed by the court.
In promissory estoppel, there is a definite promise against which the expectation arises that it will be fulfilled. But in the case of legitimate expectation, it is similar, but there is no explicit promise. It's only an implicit promise, either from some administrative action or a practice that has been consistently followed,
by the administrative authority. So it's a promise of a right or expectation. The scope of the doctrine of legitimate expectation is wider than promissory estoppel because it not only takes into consideration a promise made by a public body but also official practice as well. Under the doctrine of promissory estoppel, there may be a requirement to show detriment suffered by a party due to the reliance placed upon its promise. However, no such requirement is present under the doctrine of legitimate expectation by the court. English law has distinguished between promissory estoppel and legitimate expectation as distinct remedies under private law and public law. The scope of the doctrine of legitimate expectation is wider than promissory estoppel because it not only takes into consideration a promise made by a public body but also official practice as well. Under the doctrine of promissory estoppel, there may be a requirement to show detriment suffered by a party due to reliance placed on its promise, but there may not be necessary for such a requirement under the doctrine of legitimate expectation. In Monet Espat and Energy Limited versus Union of India 2012, Justice Gokhale of the Supreme Court highlighted the different considerations that underlie the doctrines of promissory estoppel and legitimate expectation. He said, for the application of the doctrine of promissory estoppel, there has to be a promise based on which the promise has been acted upon to the prejudice of the claimant. In contrast, while applying the doctrine of legitimate expectation, the primary considerations are reasonableness and fairness of state action. Monet Expat refers to a case challenging the decision of the Department of Mines and Geology, Government of Jharkhand, to withdraw the recommendation for grant of mining lease in favor of the appellants in the iron ore bearing areas in Motsa Kotkuri, West Singham district, Jharkhand. The court stated the doctrines of promissory estoppel and legitimate expectation are founded on the concept of fairness and arise out of natural justice. In J.P. Bansal versus State of Rajasthan, it was stated that both the doctrines, promissory estoppel and legitimate expectation, require satisfaction of the same criteria and arise out of the principle of reasonableness.